Bob, what's the general mood here in town with what's been going on last week?
Well, basically, people have become more aware of the fact that you're not safe in your own home and that you can't depend on law enforcement to protect you 24 hours a day. At the time a personal crime is committed, it's strictly you and whoever is committing the crime. Your law enforcement can come make a report, they can investigate, hopefully they can arrest somebody. And with any luck at all, perhaps the courts may even punish them. Can't depend on that. You know, it's a shame, really, that it's come to the point in this country that in your own home you have to be afraid. You have to lock your doors, lock your windows. And more and more people are realizing they have to have some kind of protection. And we're having more people buy guns than ever before, I guess.
You're selling a lot more guns here.
We're selling more. For, I say, 3 years, we've sold more guns. Mm-hmm.
What about this past week? Have you noticed an increase since the murders at Florida State?
Yes, we've had a definitely, increase. It hadn't been real large. It's noticeable because people, once again, you get conscious of it. You go along for a while with no real bad crimes going on, and people relax, and as soon as something happens, they become aware again. The guy say, well, geez, my wife is home at night by herself, and she needs some kind of protection, or these students live in the dormitories or in apartments that need some kind of protection. And once again, you can't depend on a policeman to be standing by when you need him, because there are just not that many policemen in the world.
What about the businessmen around this community? Are the businessmen pretty tensed up by this situation?
I can't speak for everybody else, but of course I'm conscious of it, and people that come in here, everyone's conscious of it. And you have a high instance in this area of your small stores being robbed, your liquor stores, your mini markets, and so forth. And more of these people are arming themselves, by the way. And I think it's not just here and not just this recent situation. Of course, this brings it, out in the open where everybody's conscious of it. But all over the country, people are becoming more and more conscious of the problems that we're having. I'm getting afraid. I'm afraid I have to go home after work and it's dark, or I stay by myself. I had a little girl in here. I wish you could have been here, 3 months ago, I guess, who came down with her boyfriend to buy a gun. 2 or 3 times in that week, she'd had somebody come in and try to, knock her door down, this kind of thing. Mm-hmm. Of course, by the time any law enforcement gets there, the guy's gone. So she came in and bought a gun. She said, next time I'm going to just empty the gun through the door. Mm-hmm. Well, I mean, what would you do? She was scared to death. Mm-hmm. And you have a lot of this. Your nurses get off late, you got waitresses that get off late, and they're all getting afraid. I don't know whether they're just going to force her off the road just being bad or what, but people are mean. Mm-hmm. They really are, It's a shame. I don't know what the world's coming to. Mm-hmm. But I personally wouldn't go from here to my house without a gun.
Is that right?
No, really. You can get away with it or what? If someone is holding you up and you've got any chance at all of getting a gun, I think you're smart to go ahead and take that chance of getting it, since you're probably not taking any more. I'm going to make a darn good try. I don't know. We got to have a turnaround in this country. Our courts have got to do it. A policeman can't do a job if the courts won't let him do a job. And it's just like this thing here. Our sheriff, with his knowledge, has already declared the guy insane, so he's already got it whipped when he gets to court, if they ever catch him. Mm-hmm. And we had a murder here about, must have been 12 years ago. I can't remember the exact year, where a young man killed 2 girls out here at one of the sinkholes. They sent him to Chattahoochee, naturally being insane. Anytime you're killing anybody, you're insane unless you're defending yourself. I mean, that's being fired accidentally. A lot of people will take an automatic and remove the magazine, which is loaded, and they think the gun is not loaded. But you pull the trigger accidentally, it won't hurt anything because it'll be on an empty chamber. Well, I think this is the wrong kind of psychology, because you might pick it up the first time, which is a stupid thing to do, but people will pick them up and snap them. And snap that first one and say, gee, this is not loaded, and they had it pointed in the safe direction. The next time, they may be pointing at you, and that's not smart. So you should, the way I look at it, all guns are loaded, and that way you're safe. Just assume that it's loaded and treat it as a loaded gun, and don't be snapping and don't be pointing. A gun is as safe as you want it to make, and it's as dangerous as you want to make it. Just like your automobile out there. If you got an automobile and
Shorter.
Yeah, I think it would be better, you know.
Yeah, I have this gun coming in 22 and 38 caliber.
32.
And what'd you say this one was?
That gun will run you around 85.
85. That's about what I was looking for.
If you like, if you can wait over the weekend, I'll have it in by Monday or Tuesday.
Okay. I think I'll just wait.
This is a very popular gun with the women, by the way. The shorter barrel on
All of the models
Yeah.
coming in.
it. It does save you some money.
Sure, you might mention on that one, the ones that are coming in have the swing out cylinder, which is a
Yeah,
better
this
model.
does not have a swing-out cylinder, and most women prefer a swing-out cylinder so that they can load and unload the gun, very easily.
The cylinder seems to have a little play in it. Is that?
It has to have a certain amount of
Does it? I thought it would be tight. Okay. Guess I'll do it.
Excuse me, you say you're buying a gun for your wife?
Yeah.
Why?
Well, everything that's happened, I feel she needs some kind of protection. And if I'm not there, I at least want, her to have something.
What's your name, sir?
Ken Purvis.
Purvis?
Mm-hmm.
Thanks a lot.
Arrested in Pensacola or failed and refused to properly identify himself, so we don't know who he is. Tallahassee has issued a warrant for his arrest for the larceny of credit cards, and I'm assured by them that they're going to issue warrants for his arrest on additional charges. This man is also a suspect in a killing which occurred.
The affidavit has the defendant listed as Kenneth Miser. That is not your correct name?
No, sir.
Are you represented by an attorney?
No, sir.
Are you able to hire an attorney?
No, sir.
Do you have employment?
No, sir.
Do you have any money?
No, sir. Well, wait. $125.
Your Honor, he is
Well, but, excuse me. That money, I think, is in evidence, so I'm not so sure that can be used.
All right.
Your Honor, while he may not be a representative of the public defender's office, he has consulted with them.
I find that he is eligible for service as a public defender. The public defender's office will represent the defendant.
Good morning. I can't tell you that.
you will be arraigned 3 weeks from today. Thursday, March 9. You are familiar with the charge against you. You have consulted with the public defender's office.
Well, I've been interviewed by an interviewer. I have not consulted with a public defender's attorney.
Are you acquainted with, or are you familiar with the charges against you as outlined by the state attorney?
I would like the court to list them again. I don't believe I picked everything up the state's attorney had.
This is for possession of stolen property, an automobile, possession of stolen television, possession of stolen credit card, 21 counts, possession of stolen tag, that is automobile tag, battery on a police officer, and resisting arrest with violence. Your attorney can give you more information as to these particular offenses and advise you of your rights.
Your Honor, it appears that the only reason the state attorney's office is indicating they would not like a bond set in this case is because they've decided he's a suspect in apparently a homicide in Tallahassee. It appears the only reason they've decided he's a suspect is because he came from Tallahassee. He is entitled to a bond on these cases because it's not a capital felony, it's not a life felony.
On the Daily Mouse, we don't even know who he is. We won't tell us who he is. Who would be the principal of the bond?
Your Honor, all I know is what they say. Now, I don't know whether he's given his name or not. He's certainly entitled to a bond in any event, I would think.
You know, the public defender heard the man admit just now that he's not the person whose name he gave, and he's failed to come forward with the correct name.
Well, as soon as he comes forth with his correct name or the authorities are able to identify him, he will be entitled to bail and it will be fixed either by me or some other judge or name. But until we find out who he is, there's no way we can bail him out.
All right.
That's all. Thank
I know, so you gotta feel
I don't know.
Mr. Roberts, my name is Ted Bundy. And I'd just like to introduce you to my counsel, Margaret Good, the woman sitting at the counsel table, and Lynn Thompson. He'll be questioning you about some things that we're interested in. We also have a couple law students who are helping us out on jury selection. Now, Mr. Thompson is going to be asking you questions that are important to us to determine whether or not we want you to sit on the jury.
Judge, perhaps we better approach the bench. If we approach the police. Come on.
If there are any...
Thank you, ma'am.
Mr. Roberts, having introduced my counsel, I'll now ask Lynn Thompson to come over here, and he's got some questions. Thank you.
Go ahead, Mr. Bundy.
I don't know that we have a copy of it, Judge.
You don't have a copy of it, Mr. McKeever. I don't have copying facilities in my jail cell in the Dade County Jail.
Judge, I'm not speaking to Mr. Bundy, and I'd appreciate it if we follow the rules of evidence when we're handling this case.
We are going to not consider a motion that you have providing a copy of. Let him see your motion, and then you may present.
Thank you, Your Honor. We're going to bring that issue up to the court because that is one of the questions I think we have to determine.
Now, you may speak on the motion as they read it, and I will consider to see the written motion, so you may proceed.
Thank you, Your Honor. As the court knows, I was being held in the Leon County Jail in Tallahassee, Florida, during the time the venue was in Leon County, and was transferred only yesterday to Dade County Jail in preparation for proceedings this morning. In preparation for my transfer, I was informed by the Leon County Sheriff as to what items of my personal property I could bring and what items I could not bring. And I was informed by the sheriff, and it was in fact the case, that I was only allowed to bring files directly related to the Omega case and COVID. I was not allowed to bring with me any legal files or any legal materials or any legal source books. I might inform the court, for instance, in that category of things I was not allowed to bring was the Florida Rules of Criminal Procedure, of all things, the basic text. I was not allowed to bring typewriter. I was not allowed to bring stationery. I was not allowed to bring pencils, pens, envelopes, stamps, or anything with which I could prepare and otherwise participate in this offense. It's only through a last-minute gift from my attorney last evening that I was able to get a hold of a pen to write the motion that we have before the court today. Not allowed to bring with me my files in the Lake City case, which, in the absence of those files, would preclude me from conferring with Mr. Africano, who was recently appointed to represent me in that matter. I was not allowed to bring with me legal files concerning collateral acts which the state intends to introduce in this proceeding, such as those acts involving credit card transactions, or those legal files dealing with the theft of a white van, which may or may not be a collateral act in this proceeding. Upon arriving in Miami and being booked in the Dade County Jail, I was taken to the 4th floor and spoken to by Sergeant Kratz of the Dade County Jail. And after Sergeant Kratz informed me of the rules and regulations of the jail, I was placed in a isolation cell, also known as a strip cell, also known as a punishment cell. The cell is approximately 9 feet by 7 feet. It's illuminated by a light source which is well outside the cell and must filter through the steel bars into my cell. It has a shower stall and a bunk and a stool and a table built into the side of the cell wall. For all practical purposes, Your Honor, the cell effectively frustrates my ability to participate in my own in the preparation of my own defense, since the light source is totally inadequate to read by. The only way one can read in that cell is to hold a document outside the bars and read the document with the available light that filters from the light source outside the cell. The table and stool are totally inadequate because they're designed for right-handed people, and I unfortunately have the handicap of being left-handed. There's no way you can write on that stool and table being left-handed. There's a further question as to what I'll be allowed to have in my cell and to whether or not I'll have exercise. Your Honor, considered individually, perhaps my complaints may seem insignificant, but I would ask the court to consider in their totality their impact on my ability to cooperate with counsel and participate with counsel. I might also say that because the Leon County Sheriff's Department waited until literally the last moment to bring me down here, I have not had an opportunity to fully discuss with counsel the proceedings which will take place today. And I will also state for the record and inform the court that since the change of venue ordered by this court in Tallahassee, and I don't know, I guess that was 10 days ago or 2 weeks ago, I have been able to consult with my counsel a total of approximately 3 hours in Tallahassee, and they came by last night at the top. I feel that with the amount of time that my counsel have had access to me in these past 2 weeks, we have not been able to work together. They have not been able to inform me as to the course of the defense, both prior to the selection of the jury and during the selection of the jury, and for that matter, during the trial itself. And I would inform the court that one of my complaints that I voiced to Your Honor in Tallahassee was that I did not know, and I still do not know, any of the names of the witnesses we're going to be calling, what we're supposed to get out of those witnesses, what part I'll play, if any, in examination of those witnesses, and so on. And I don't think this is because my counsel don't want to tell me. They've been pretty darn busy. They've been so busy chasing their tails almost that they haven't had time to talk to me. And I think that the very nature of that limitation is also a limitation on my and my effectiveness as a defendant. What in the world can I add to a defense I don't know anything about? This is what, Your Honor, the Feretta Court, United States Supreme Court, was addressing itself to when they said that a defendant, the right granted by the Sixth Amendment is a right granted personally to a defendant, that the state cannot force upon a defendant a defense which he does not want. And I would say that by implication, the state cannot force upon a defendant a defense he has no knowledge of and no participation in creation. And
I understand the scope of your motion.
Okay. Let me simply say that the relief I request in that motion is the return of legal documents, the improvement of lighting, exercise, and a number of other things I'd like the court to consider and rule on at the earliest possible opportunity. And there is also a motion, if I'm not mistaken, before the court by Ms. Good, a motion to continue based upon, in part, our inability to confer with one another.
Mr. McCabe?
Well, it sounds to me mostly like just in-house things, Judge, that can be worked out with the jail personnel and really Mr. Harvey or whoever wants to bring it to the court's attention. I feel like we've already argued this thing in Tallahassee about how much assistance he's got a right to and what kind of counsel and all that stuff, so I'm not going to belabor the court with the same arguments I've already made. I just think we can work this stuff out in-house.
All right, on this defendant's motion.
Even before the trial of Ted Bundy gets underway, the death penalty is a major issue. Bundy is on trial here in Miami for the brutal murders of 2 Florida State University co-eds. He is a suspect in at least 19 other murders. Under Florida law, if Bundy is found guilty, the jury will also recommend whether he should be sent to the electric chair. Considerable time is being spent asking each potential juror his feelings on the death penalty.
In other words, do you have any moral or religious scruples about the death penalty that would just prevent you from considering the case in chief, the unanimous verdict?
If you have to face the law, you have to.
For some, that weighty decision makes it difficult to even come up with a verdict, and they are excused.
Could you return a verdict of guilty, even though it might lead to the recommendation? No. Being a possibility? Judge, move the cause.
In a highly unusual move, the defense has hired an MD hypnotist to tell them which jurors would most likely vote in Bundy's favor. Dr. Emil Spillman bases his predictions on voice inflections and body language. It is a questionable science at best, but the defense attorneys say they want to take every precaution to keep the 32-year-old former law student out of the electric chair. Rebecca Chase, ABC News, Miami.
We'll take a little recess now. How much more time are we talking about, gentlemen? Let's try to do some organization as far as scheduling is concerned. I'd like to finish these matters tonight and be ready to start opening statements in the morning.
Judge, I've got a real problem with that. We don't even know what evidence is coming in.
You will know before the night's over.
Yes, sir. But I would really appreciate the court to give us the indulgence to let us work on the opening statement until Monday morning.
I think we've had that jury languishing there all week, and I don't see any problem with getting opening statements behind us in the morning and then begin your evidence. You and I know that the defense probably wants to reserve their opening statement anyway, and if they want to, bless their heart.
Judge, I can tell you right now we're not going to reserve the opening
All
statement.
right, then we're going to give it in the morning then.
Judge,
We're going to proceed with opening statements in the morning. I just want to find out how much later we're going to go tonight.
well, Judge, this motion itself, I don't know how long it's going to take. We've got to argue
We
it.
got 12, 13 more hours, and I just witnessed a man talking from 1 o'clock in the morning to 10 o'clock the next morning. That can't bother anything. So if they're able to do that, I don't see why we're not able to.
Fine, Judge. That's all right.
Just want to go ahead and finish it tonight, and then we don't have to start it at 9 o'clock or 9:30. We can start here at 10 o'clock in the morning. That's when I've got them scheduled to be here.
Judge, all I can say is that I would really enter an objection to it and request the court that the opening statement is going to be perhaps the most important part of the trial. We've been working on these motions and have...
And I'm going to instruct them that the opening statement is not evidence, and they're not to consider it as evidence, and whatever the attorneys say is not evidence. And that's your most important part of this trial we've been laboring on for 6 months.
Judge, it's going to be the next most important part of the trial we're going to get to.
It better be the next most of it. You would just upset me a little bit if you said that was the most. I don't see any reason we can't proceed with open statements in the morning.
Well, I do, Your Honor, because my attorneys are not ready. They are entirely unprepared to start trial tomorrow morning. They have not even begun to put together the opening statement. They have not begun to decide who's going to be doing what in this trial. They are trying to catch up and not getting anywhere.
We started this trial a week ago. That we'll schedule opening statements tomorrow morning, 10 o'clock. We'll let the record show your objection. We'll overrule it, and we're going to proceed at that time. We'll finish these motions tonight. We'll be in recess for 10 minutes.
They'll start it without me, Your Honor.
Everybody be seated.
Will not be a trial.
Mr. Bundy, sit down, please, sir. Court will now be in recess for 10 minutes.
Nobody. I don't care who he is. Nobody.
Let's just wait 1 minute so we can get the inside rolling in there.
Thank you. Mel, I'm glad you thought of that. Nobody else would.
All right, gentlemen, we have 15 minutes. That was the ground rule, so. Q&A.
Judge?
Yes, sir.
What kind of reaction, or we couldn't see Mr. Bundy's face as he stood being sentenced. Could you tell us how he reacted and what your feelings were as it happened?
I think I tried to intimate to, or tell to Mr. Teller that particular concepts of the case and insights to the case, I don't think are really appropriate for me to comment on because we've got motions that are pending before us now and various other factors. It's difficult to read reaction or anything like that, but...
You personally think he's guilty?
Do I personally think he's guilty? I don't think that question is appropriate to ask the judge. I wouldn't have sentenced him if I hadn't, because the jury made the finding.
Is that the most difficult decision you as a judge faced, the sentencing, the final moments of a trial?
I think without a doubt the most difficult proceeding there is sentencing from a pure judicial standpoint.
Were there any surprises to you in the trial? Anything surprised you at any point in the trial?
Not per se during the trial, no.
Judge,
Excuse me, Mr.
Judge, you made some mention about the law not being set in concrete or inscribed in concrete, that is the capital punishment law. Would you like to elaborate on that and your feelings perhaps about capital punishment?
Mr. Larson, there probably is nothing as vacillating in the world as legislatures. And that's the reason for the comment. It might be changed, it might be altered. Supreme Court might make different concepts. Personnel, judicial personnel change, thoughts change on high benches. Anything is conceivable. But of course, as a trial judge, you take the law as it is at the time you make the decision, or you think it is. And that's the concept. It's not a breath of hope, or it's not an expression of personal feeling. It is simply is a fact of life that conditions change. The law is an organism. We hope it remains an organism. That's the intrigue about it. Sort of like your business. There's something that comes along basically every day, and it is an organism.
Judge, talking about our business, what would you think of Mr. Bundy's attack on the press? He seemed to blame us for his plight.
Well, I guess you can say it's an old thing. As a old-time lawyer, when you got a client that you're worried about his guilt or innocence, try everything in the courtroom, including the court. I don't have much comment about it. I didn't have any problem with the press. I thought all of you conducted yourselves the way that I expected you would, and anticipated you would, and really knew you would.
You talked just a moment ago about the changing ideas in the legislature. These decisions, of course, are retroactive then if they make them.
Might or might not be, Milt.
No, this is something that buoys these people up while they're fighting. It takes 3 or 4 years before the conviction and signing of a death warrant, doesn't it? Before
sometimes longer than that.
Judge?
Yes,
you
sir.
seem deeply concerned about mitigating, or the lack of mitigating evidence presented by the defense, especially Dr. Tanay's findings. Could you explain that to us a little bit?
Well, that's fairly well set out in the judgment, the feelings that we had on it. We kind of commented within the framework of the sentence structure and that fact, and the ones that we alluded to. I really would suggest you sort of look at what we said. There again might be something that I've got to talk about in the future, you know, and it's just that what we set forth in the findings and in the sentence, as the written sentence as prescribed by law, is the way we feel.
Judge, might we expound on a question before? Mr. Bundy complained not so much against the press itself, it seemed, but the magnitude of the satellite transmissions and the incredible, just the sheer amount of stories that went out to so many markets all over the country. And I wonder if you had thoughts in that respect, that the sheer amount, and magnitude of the press coverage really hurt his chances at a fair trial, and that by being there, there's an inference of guilty. Did it hurt his chances for a fair trial?
I don't think that there was, when you're operating under the guidelines that we have, what happens once that it's disseminated and left the courtroom should not and does not, in my opinion, have any impact. If the jury were not sequestered and were reading it all, I could see the possibility of it. But there are safeguards and there are procedural matters that you invoke for the protection of that. I don't see, and I guess I've expressed this previously, a direct combat between the First and the Fifth Amendment. We've said that many times. Our Sixth Amendment, our Fourth Amendment, they're all basically engrossed in it.
Overall, Judge, did he get a fair trial, considering the jury process, considering things you did and felt had to do? Was it, in your experience?
I think you're probably a better judge than that. I don't know of any decision I would change that I made, if that helps you any.
Judge, you were privy to much more information than the jury could actually hear in this case. And did that additional information that you knew about the circumstances concerning the crimes make the job of sentencing any more difficult, any easier, any more clear?
We didn't use anything that, as we said, under Gardner, that which is a pretty controlling case, that was not known to the defendant. Certainly there are things that the jury wasn't privy to during the guilt or innocent phase that we have to suppress. We felt that the law requires suppress under the exclusionary rule. But those factors, when we exclude them, we only review for the purpose of looking at the whole and total record when you sentence, that's all.
Aside from the sheer magnitude of the coverage, do you regard this to be an unusual trial or in any respect, and if so, how?
I don't think it's per se an unusual trial. It was a protracted trial. Most all trials are unusual in that they're different people, there are different personalities, there are different factors involved in them from a standpoint of evidence, from a standpoint of police work. I think we started at the first concept of this, that our hope and our aim was to try to put this concept into a basic simple trial, and none of them are simple when you got a charge of first-degree murder. Yes, sir, I'd be Williams.
All right. Your Honor, you said in your goodbye to Mr. Bundy that you're a bright young man. It would have been good if you could have ever practiced in front of me. How do you rate Bundy as a lawyer in the he conducted a large segment of his own defense?
The answer to that is he really isn't a lawyer. He's never gone through all of it. In the aspect that he's saying, Mr. Bundy is very articulate, very personable. Basically, on this side, as we saw him under the courtroom structure, human being, and to that degree, we feel that. I feel strongly that way. You've got the comments that I made in the courtroom, and I think I indicated that. I think he indicated that. Yes, sir.
Howard, do you have any idea how much Dade County taxpayers had to pay for this trial?
I can only answer that like I will tell you that all the other costs, there's none that will be taxed that weren't necessary for a pure, fair, and impartial trial. Only additional costs have been by virtue of jury sequestration, and this little gathering here is one of the strong reasons that those costs were necessary. So I don't have any factor, I don't have any idea on
Would
that.
Leon County help bear the cost?
Judge, do you expect your sentence to be carried out?
Do I expect?
Yes.
I certainly don't hope you think that I sat there and exercised something in futility.
No, but given the context of the political situation these days, do you expect the death penalty to be in effect by the time it happens?
One of the first things that you learn in the legal business that not to prognose the legislative, and I just don't know the answer to that. I don't say that to you in curtness. I say it to you because, as we talked about previously, legislative ideas and concepts change.
How soon do you think it would happen? A sentence of death could be imposed. How long does it take in the legal process?
I don't know. We've got some that have been there 4 or 5 years. Yes, sir.
Judge, it seems fashionable nowadays for condemned men to withhold an appeal grant until their death warrant's actually signed. Is there any way that you can make sure that the appeal of ineffective counsel is brought up before?
That's a direct question on future proceeding. It might be before me. But if you go back and look at 2 or 3 comments we've made through the trial, you're going to find the answer to that.
Mr. Bundy said himself that he thought that you would impose the death penalty even if the jury recommended mercy. Was he correct?
He was correct in what his own thought was, I assume, but there's nothing that's binding as far as I was concerned. I didn't know what the jury was going to do. I didn't know what I was going to do.
Judge, are you concerned at all about the comments made by Mary Russo since the jury was released?
Well, that's
her
something
concern about...
I can't comment on because I might have to rule on.
Have you ever gotten to know a defendant in a criminal proceeding as well, perhaps, as you've gotten to know Mr. Bundy?
Yes, sir. Sure have.
Judge, going back to the final comment you gave Mr. Bundy, it seemed like that you were genuinely emotionally touched by the prospect of sending a man with such a promise to death. Is that true? Were you
I think
emotionally
he
touched?
said it probably more eloquently than I said. Behind all that robe, you're still a human being. How can you not be concerned? How can you not be cut? It's not a pleasant thing to do. It's an obligation, just like when you answer a draft call. And the lieutenant says you climb over the hill, you got to do it, but it isn't something that you want to do or like to do. Certainly you're concerned with it. You'd be inhuman if you weren't. And God knows I'm human.
Concerning an appeal, if and when...
Pardon?
Concerning an appeal and the magnitude of the coverage of this trial, if and when there is another trial for Bundy, is there any place in the state of Florida, do you think, that they could get an impartial jury this time?
We can get a jury.
Where?
Tallahassee.
What about the letter from Margaret Bowman's father? Did you read that before you made the sentence?
No, sir, I still haven't read it.
Do you intend to?
Don't know where it's at. Yeah, you bet I'm going to read it, but I'm not going to read it yet.
Do you know which circuit appeals will be heard in this case?
Supreme Court.
Judge, were you speaking literally when you said a few weeks ago that you thought that Bundy's defense team was the best you had ever seen?
From a legal standpoint and from a point-raising standpoint and from a briefing standpoint and from a numbers standpoint, absolutely.
What standpoint that would be covered?
What standpoint? I don't know of any. I don't know of any.
Does that suggest, Judge, that you had before you defense teams that were less?
But I've had defense teams. I've had a lot of them less in number, my friend. I assure you that.
Judge, did you ever get the sense or feeling that Bundy was engaged in any kind of role-playing, that he divorced himself from the actual crime or the event, that he really considered himself innocent and that he was playing the role of a lawyer or something like that?
I didn't get such an intuition. I didn't get such a feeling. I might have. I don't know. I didn't look at that from that standpoint. Never thought about it. Really, I had some comment raised about it in, I think, the competency proceeding, but I didn't sense any such thing as that.
What feeling did you get then from his behavior and his attitude, demeanor in the courtroom?
Depends upon what day it was. I got quite a few feelings from it.
Let's tell you, I mean, an overall view of his capacity is...
Well, what do you expect a man to do who's on trial for the charges that he was on trial with? If he didn't vigorously try to defend himself, something would be wrong with him. I don't see anything that has impressed me concerning that. I really don't.
Two questions for you. We talked, right when you were first appointed on this case, we talked up in Tallahassee, and you said to me, calm down, this is just another trial. Do you still feel that way?
Sure do.
You do?
You sure do.
Just another trial?
Yes, sir.
The other thing is, might you be moving to Tallahassee to take a seat on the Florida Supreme Court?
I am running and moving toward obscurity. No, sir.
Not after this trial, sir.
You bet I am. That's even more reason.
Thank you, Your Honor. Thank you.
Thank y'all be careful. Good to see y'all. Come back and see us.
I got you attached. Got a leash on you. I had a leash on you. Tell me that.
Yes, sir.
How long have you been on the bench, sir?